Does the new ruling affect Ripple? Is Judge Torres going to be on the front now? And will the end in August as Attorney Hogan predicted? Stay tuned till the end of the video to find out. But first, we are giving away 50 XRP coins at the end of the month to one random subscriber to start on their XRP journey. All you need to do is to like the video, subscribe and comment your thoughts on XRP in the comment section. Welcome back XRP Army. Let's grow the XRP Lab community by pressing the like button and subscribing to this channel to stay updated at all times. Amazing things are occurring in the SEC versus Ripple case. First and foremost, we have evidence, some of which is quite fantastic, which we will analyze. It is evidence for the SEC, just to give you a heads up on what is going on with that. In addition, Judge Torres has arrived, and I have a strong impression that she is going to take this case ahead quickly and aggressively from this point forward. The fact that this case is likely to be a little complicated means that she has a large task ahead of her. As you may be aware, the name you have been hearing is that of Judge Sarah Netburn, who is primarily responsible for discovery concerns. Nevertheless, it is Judge Torres who will be making the ultimate judgments in the case. And she walked into the case with weapons blazing the day before. And here is the order, which consists of 3 dispositive motions, as follows. There were 3 outstanding motions at the outset of the order opening paragraph, and there were requests to seal documents in connection with each of those motions. Firstly, Larson moved to dismiss the lawsuit against himself, followed by a second motion to dismiss the case against Brad Garlinghouse, and finally, a motion to strike the fair notice argument brought by the SEC. What do you think? Will it favor Ripple? Also, she is not making a decision on these motions at this time, but she is discussing which papers, or which portions of documents, the public will be able to see. You have 2 options when it comes to papers that have been submitted with the court. You may seal them or redact information from them. When you redact a document, it refers to the process of simply blacking out certain sections of the text. Also, what the public can see was a very generous ruling from Judge Torres. So, taking a look at the sealing section, it states that the common law right of public assets access to judicial documents is firmly rooted in our nation history. This presumption of access is based on the need for federal courts to have a measure of accountability and for the public to have confidence in the administration of justice. To summarize, if you wish to keep anything under seal, you must have a strong justification for doing so, and the court clearly did not feel that the defendant grounds were sufficient. However, bear in mind that this order has no effect on the court decision in the case since the judge has access to all of the papers, even those that have been sealed. And her order will allow us to examine a large number of the papers that will be presented on February 17th. So, are you excited for February 17th? This is all I could find out about the order, so let's have a look at what others are saying on Twitter. So, Attorney James K. Phelan tweets, Court denies Ripple request to seal legal memos provided to Chris Larson and briefing associated with those memos and grants Ripple request to file SIR reply to the SEC motion to strike the fair notice defense. And somebody named Rainey responded to Attorney Phelan, that correct me if I'm wrong, but unsealing the documents that the court and opposing parties have already viewed as more for public perception than having anything to do with the outcome of the lawsuit, right? And James responded, you are correct, it is all about public access. Attorney Jeremy Hogan took to Twitter to express his opinion that the judgment indicates that the judge presiding over the case, Annalisa Torres, will soon begin to take the lawsuit ahead. He tweeted, there is only one major takeaway from this order on the Ripple versus the SEC case. Judge Torres is getting ready to take over. The next couple of months will be very interesting with all the major rulings that are being teed up. Judge Torres' orders, according to John Deaton, an attorney representing the XRP holders in the SEC versus Ripple dispute, are a positive development for his clients. Deaton tweeted, Judge Torres' rulings are a great sign for XRP holders. What these rulings clearly show is that Judge Torres favors public disclosure. Ripple cannot seal certain documents, i.e. legal memo. The same applies to the SEC. Think ahead, we may ultimately get to see the 63 Hinman emails. Do you agree with Deaton? Share your thoughts in the comments. The 63 Hinman emails highlighted in Deaton tweet are related to the deliberative privilege issue with the Securities and Exchange Commission. Earlier this month, Judge Sarah Netburn ordered the submission of Hinman drafts and notes from his 2018 address, which John Deaton referred to as Ripple, biggest success. He said, "The biggest victory for Ripple and XRP holders, from Judge Netburn recent decision, is not necessarily the email with the draft version of the Hinman speech. The most significant victory could prove to be the notes from meetings with third parties not associated with Ripple." As Deaton added, those third parties are highly likely to include Ethereum Joseph Liban and an executive from Consensus, who recently met with Hinman and others, as well as members of the Enterprise Ethereum Alliance like the VC Working Group, Deaton saying that, "These notes are no doubt from the above meetings." Judge Netburn ruled the SEC can still invoke attorney-client privilege regarding the personal notes memo by Valerie Schepanek and others, but if the notes contain statements made by the people at the meetings, it's not privileged. Furthermore, somebody named Chappers responded to John Deaton wrote, "That's not guaranteed, as in the 63 Hinman emails, not guaranteed we are going to get them," and John Deaton responded with the following, "I did not say it was guaranteed, but if Judge Netburn holds firm that the emails are not privileged and Judge Torres agrees the emails should not be sealed." And here was this somebody named Simon Stephen responded to John Deaton wrote, "As long as there is nothing in the notes to Larson that are incriminating." John Deaton responded with the following, "The SEC and the judge have read those memos and already know what they say. If anything in them hurt Ripple case, sealing it does not change a thing. Sealing it only means we the public do not get to read it. I do not blame Ripple or its lawyers for trying to seal sensitive documents, but I want transparency across the board. And if Ripple cannot seal certain documents, then the SEC, an agency of the federal government, should not be able to seal non-privileged documents as well." Between that time and now, the SEC has been able to get an extension in its bid to keep the records from being turned over to them by the court. Because of the ongoing delays in the SEC versus Ripple lawsuit, the timeline could be pushed back to 2023, according to attorney Jeremy Hogan, who posted a video in which he questions whether the SEC delay tactics are a simple pressure play or if they are hiding something really bad that would force the lawsuit to be dismissed immediately. Now that Judge Annalisa Torres has returned to the bench, it is believed that key decisions will be made at a quicker rate. It is possible that if Hogan's suspicions are confirmed and the court decides to uphold its ruling on the DPP case, the litigation will be over much sooner than anticipated and the XRP holdings will be restored. Make sure to subscribe and give us a thumbs up. Thank you so much for watching. See you in the next video. Kindly note that the prices of cryptocurrencies frequently change, so by the time you watch this video, it might have changed to a whole new value. The information provided in this video does not constitute investment advice, financial advice, trading advice, or any other sort of advice, and you should not treat any of the content as such. The content in this video is for educational purposes only and hence should not be considered financial advice. Do conduct your due diligence and consult your financial advisor before making any investment decisions.